My name is Jed Stabler. I'm a partner in the law office of Stabler and Baldwin. I concentrate my legal practice in the area of estate planning, including probate administration and the administration of trusts. I've been practicing here in South Florida for approximately 15 years now. Having started my firm back in 1999 here in the West Palm Beach area. We provide legal services all over South Florida, Palm Beach County, and the state of Florida. When we talk about estate planning, we're really talking about 4 or 5 basic documents. And these documents are not contingent on a person's age or whether they're in good health, bad health, whether you feel like you have lots of assets or little assets, right? When we talk about estate planning, we're really talking about naming who our beneficiaries are, how our assets are distributed, but just as important, arguably even more important, we're talking about making sure that we have somebody named who's able to act for us and do for us during our lifetime if we ever needed help. Right? We're talking about avoiding a guardianship, right? Because if you or I became incapacitated, God forbid we got hit by a car or suffered a stroke or Alzheimer's, whatever the case may be, if we didn't already have certain documents in effect, we're stuck with what's called a guardianship. It's a legal determination of incapacitation, $3,000, $4,000, $5,000. The judge will appoint a legal guardian for you, just to be able to have somebody who's able to sign your name and on your behalf and make decisions for you and on your behalf. So these documents that I'm about to mention, in large part, help to avoid that scenario. And most people have heard of these before. The first is what we call a durable power of attorney. It's a legal document whereby you're able to name somebody who's able to act for you and do for you and on your behalf during your lifetime if you ever needed help. This durable power of attorney is very broad in that really almost anything you can do yourself, it's in there. A power of attorney, mind you, can be as limited or as broad as you want it, but ideally we want it very, very broad because we don't know sitting here today what may come up in the future where all of a sudden we may need somebody to act for us. So for that reason, it's intentionally very, very broad. A provision that may not mean anything today may have some relevance down the road, right? Circumstances change, so a person's needs may change over time. So durable power of attorney, it really is very broad and goes a long way in helping to avoid a guardianship. Another estate planning document is what's called a designation of healthcare surrogate. And different states have different names for it. Some call it a healthcare proxy. Some states call it a healthcare power of attorney. Here in Florida, we like to be fancy about it. We call it a designation of healthcare surrogate, but it is nothing more than a healthcare power of attorney. Like a general durable power of attorney, a healthcare surrogate is very broad. Again, we don't know sitting here today what sort of healthcare matters or issues may come up in the future where all of a sudden we may need somebody to act for us. So it's intentionally very, very broad. It goes well beyond just allowing the person named, for example, to give the doctor informed consent. To say, okay, doc, I authorize you to perform this procedure on my spouse, for example, if my spouse is unable to give informed consent, or I authorize you to perform this operation on mom and dad, right, if they're in the hospital and are incapacitated or otherwise unable to give informed consent. It goes well beyond that. If, for example, you needed help changing from one doctor's office to another, not to worry, your healthcare surrogate can do it. If you needed to hire and fire healthcare personnel or to contract for medical services, it's all in there. Right? Very, very important. Again, goes a long way in avoiding potential guardianship, because again, it allows you to name somebody who's able to help make healthcare decisions for you and on your behalf, all sorts of healthcare decisions if you ever needed help. Another basic estate planning document is what we call a living will. And the living will speaks to the withholding and withdrawal of life support. It's the only thing it talks about. It makes known a person's wish not to be kept alive by life support under certain circumstances, remember. There's a lot of misconceptions about living wills and how they work, and oftentimes people assume that no matter what, if you end up in a hospital on life support and they see you have a living will, they're going to automatically pull the plug. That's not the way it works, right? Three things have to happen in order for the doctors or the healthcare providers to be able to look at a person's living will here in Florida. Number one, the person must be chronically ill or injured, or be in a permanent vegetative state. That means the person must be suffering from an injury or illness that's going to lead to death, or be in a coma. That's requirement number one. Requirement number two, there must be no reasonable medical probability of the person getting any better as determined by not just one doctor. We never leave it up to just one doctor, but at least two licensed physicians who have examined the person. Okay? And the third requirement is you must be unable to manifest your intent with regards to withholding or withdrawal of life support. Remember, even if you have a living will, as long as you can look up at the doctor and say, "Doc, keep me on life support," or "Doc, take me off," he or she has to listen to you. The living will, remember, just hangs out there in the background. It says only if I'm ever unable to manifest my intent with regards to the withholding and withdrawal of life support, and I'm chronically ill or injured, with no reasonable medical probability of getting any better, then I'm making known my wish not to be kept alive by life support under those circumstances. You do two very important things when you have a living will. Number one, you're not leaving it up to somebody else to say, "Okay, I think this person has suffered enough. Take them off life support," right? That's number one, because you've already stipulated the circumstances under which you don't want to be kept alive by life support. But here's number two. And when you have a living will, you're really doing a caring thing, because you're sparing the ones closest to you from having to make that difficult decision. It is very difficult for spouses, for children, for other loved ones and relatives to have to be the one to say, "Take this person off life support." And a lot of times there's a lot of guilt associated with having to make those decisions. Well, when you have a living will, you've really done a caring thing, because you're sparing your loved ones from having to make that decision. Why? You've already made it. You already have a living will. Thank you for joining us today and watching our video. I hope you've learned a little bit about what we do and revocable trust agreements and probate. Please feel free to contact the firm either via telephone at 561-471-7100 or through our website at jedastablerpa.com.